I think we're ready to begin. I wanted to thank everyone for joining us for our annual OSHA update webinar. And we always look forward to this webinar as an opportunity to ponder the last year, and this has been quite a year for all of us, and report on the developments on the OSHA front in the last year. And of course, we cannot go without addressing the COVID emergency temporary standard, but we have lots of other things to report. And so we will discuss all those different issues, the three of us. I'm very pleased to be joined by Fred Walter and Megan Shickhead. My name is Andrew Sommer, and we're from Conn-Maciel-Curie. We're a boutique labor and employment firm. Our focus is on OSHA, specifically OSHA, the three of us, as well as employment litigation. And want to just briefly introduce ourselves. I'm managing partner of the California practice. I've been practicing for over 20 years. My experience traditionally was in employment litigation, such as wage and hour litigation and wrongful termination litigation. And over the years, I've developed a specialty as well in OSHA enforcement. And that's a big part of my practice, and as well as advising employers on various different employment related matters. Also want to introduce just real briefly the whole team. Fred Walter is of counsel with our firm. He's been practicing for over 30 years. He knows quite a bit on the OSHA front, has relationships with folks in the agency and in the practice, and has really key insights that I'm certain he will share with you today. And he advises businesses on workplace safety concerns and defends employers in OSHA enforcement proceedings. And last but not least, we're joined by Megan Shickhead. She's our labor and employment associate. She has a dual specialty like I do, and focuses on employment litigation, OSHA enforcement, investigations, as well as employment-related counseling. So without further ado, let's just dive in to the subject matter here. The topic really today is we wanted to give you a broad overview of what's happened with OSHA. So to start off with, we're going to review the status of the Division of Occupational Safety and Health, which is DOSH, the enforcement agency with OSHA, and what they've been up to historically, as well as during the pandemic in terms of the developments in enforcement. We also will discuss legislation and rulemaking that has or that are actually in the works, as well as rulemaking that has been approved in roughly the last year as highlights. Another focus of today's webinar will be on the OSHA COVID-19 Emergency Temporary Standard that was approved a few months ago. Has had major impact, of course, on workplaces. We do have an independent webinar on the OSHA COVID-19 ETS, which is available on our website as a recording that you can review separately for more content. I did want to take the opportunity here to emphasize that the slides from today's presentation, as well as the recording that we're taking right now, will be available on our website as well. And so if there's something you missed, or if you have a colleague that was unable to attend, that person can go to our website and view the webinar. And then lastly, or close to last, on the COVID-19 front, Megan is going to address the notice requirements under the various patchwork of legislation and rulemaking. So we have notice requirements under the OSHA Emergency Temporary Standard, the ETS, as well as under Assembly Bill 685 and Senate Bill 1159. And lastly, we wanted to cover with you the Wildfire Smoke standard. That standard did initially pass its emergency standard a while ago. There was an update and amendment to that standard recently, but this is such an important standard given its impact in our state with the high incidence of wildfires in the state. that this will be something that will be a good refresher, we believe, for many of you. Now, turning to the next slide, let's just dive into enforcement issues. First of all, there are a number of standards that have been approved since July of last year. We wanted to just briefly review those with you. Just as a refresher, we have the COVID-19 Emergency Temporary Standard that was or took effect November 30th of last year. And some of these other rules may not be pertinent to your industry, but just as a very kind of high-level overview, there was a standard that passed in October concerning tree work, maintenance, or removal, specifically the use of portable power saws. And then there was a standard in July concerning elevators for hoisting workers. There was an amendment to the existing standard. And then a standard that will impact all of you is there was an amendment to the Injury and Illness Prevention Program standard concerning employee access to that program. And so now there is a requirement to provide employees access to that program document where there previously had not been in the past. And it is recommended that you update your program to incorporate that access component. And the last two rules that have passed are, well, one is less substantive in a way. The single user toilet facilities rulemaking essentially incorporates into the OSHA rules the existing mandate under state law about providing an all-gender restroom where the restroom is for single use only. And a real significant standard with a whole lot of content is the outdoor agricultural operations standard that relates to operations in nighttime and the illumination requirements specifically. And then next, there's a number of standards that are under consideration, and they actually have been under consideration for some time. And this is largely attributed to the COVID-19 pandemic, as is expected, and the considerable amount of efforts around the rulemaking over COVID-19. So the COVID-19 pandemic has essentially taken the oxygen out of the room. There has not been a lot of other rulemaking. Our last review of the Standards Board's website, and that's the agency that will promulgate rules in the OSHA context, shows that a number of rules that have been in the works for some time are identified as TBA, to be announced for meetings, and that there is no update on their status. One very significant rule that's been in consideration for a while is the heat illness prevention standard for indoor places of employment, and that's in contrast to the existing standard for outdoor workplaces. And there's been a whole lot of controversy over that proposed rule, since it does have a number of onerous requirements, at least in the present iteration, and significant uncertainty about its scope. There's also a standard being considered for general industry workplace violence, and that is a supplement to the healthcare workplace violence standard that's been in effect for a while. Also a standard being considered is one impacting the marijuana cannabis industry, and that's specific to cannabis establishments. And the last two proposed rules are specific to healthcare. One is related to surgical plume and smoke, and the other is anti-neoplastic drugs standard that is specific to cancer treatment medication or that are used in the healthcare context. So that's the status of rulemaking. And another area that we felt was important and we like to address in these annual updates concerns the enforcement data by the Division of Occupational Safety and Health. And this data is publicly available by the agency. We don't have data, at least that we're aware of in the last year, But this data shows the trends from 2015 to 2019. And there are some significant trends here that we did want to share with you. And one is specific to the businesses investigated. That number there, it shows that there are figures between 13,000 and 15,000 inspections statewide by the agency in that calendar year. And now that the investigations concern both letter requests and on-site inspections. And so there was a fairly consistent trend of this being around 14,000, 15,000. We're seeing in the last couple of years it's fairly consistent in the number of investigations. I would expect there to be a drop-off during the early part of the pandemic, at least what we were hearing anecdotally. In terms of the violations per inspection, and the inspection would be the on-site inspection, there's a high number of violations. The data is surely showing that when OSHA comes out to investigate, in most circumstances, they're finding a violation and citing the employer. So we're seeing in 2019, there's 2.41 violations per inspection. And then below that is a row with the number of violations that are between 18 and 20,000. And what is significant is the number of serious violations. And no employer wants a serious violation on their record. A serious violation has enhanced penalties. And we're seeing in these statistics that there's between 20 and 23% of the violations being classified as serious during this 2015 to 2019 timeframe. And we're seeing most recently in 2019, it's at 23%. And I think that's what we're all seeing, is we're seeing a number of serious violations in these citations. There are cases where they could all be general, but we're seeing, at least in recent years, a clear uptick in serious classifications. And now the next slide addresses the data specific to the time frame of 2019, the last quarter of 2019. And I found this really interesting because it's breaking down the citations by the type of inspection. And so as many of you are aware, OSHA can come out and inspect you where there's a accident, serious injury or illness that's reported to the agency directly. Or it could be a complaint by an employee, a union, or a member of the general public. Or there could be a referral by another agency. And lastly, a common category would be a program inspection where it's already structured and planned based on the nature of your industry. Now, what is significant here is the range. We're seeing between 65% to 84% of inspections result in violations being cited. And you're seeing here that if this is a referral from another agency, a program inspection, or an accident, you're seeing a high percentage of citations. And complaints have a much lower percentage, and that actually surprised me. I thought the percentage would be lower, and it may be if we looked at a larger data set. And then regarding serious citations, you can see here in the third column that for accidents, 32% are being, of those inspections are being cited as serious violations. And then you see a much lower percentage of serious violations being cited where it's a referral, for example, from another agency. So turning to the next slide, where are we at now? We've been reviewing this data that's pre-pandemic. We all know that the pandemic has really changed the landscape here. And we are hearing that, during the early stages of the pandemic, the division just wasn't conducting inspections. They were sending complaint letters in lieu of inspections. At some point in time, even before the ETS was adopted, we were seeing a pattern of the district offices being back out there and inspecting. We were seeing a number of citations. Early on in the pandemic, we were seeing citations under the Injury and Illness Prevention Program standard, given that there was no COVID-19 specific standard. And then the ETS has been adopted. We'll see what comes out of that in citations. But we are seeing more inspections now. The division has instituted what we describe as a public shaming campaign. It's something similar to the Fed OSHA campaign, where there is on its website, the agency will publicize citations that are issued against different employers and the citation amounts. And there is quite a bit of data. You can see that on the website. We've included a link. None of you want to be listed there. But there is a pattern we are seeing from this data. The industries that are most impacted, that we're seeing as cited for COVID-19 related violations, we're seeing a number in healthcare, and that runs the gamut from nursing care, hospitals, assisted living. We're seeing also a number of citations against agricultural employers, whether that be employers that are in harvesting and in the direct supply, as well as in agricultural employers that have plants that are processing agricultural goods. Manufacturing plants are being targeted as well, and supermarkets and meat processing plants have certainly been on the list. And now I'm going to turn it over to my colleague, Fred Walters, to address the current state of enforcement in a bit more detail.
Okay, thanks, Andrew. So I suppose the word for the year for Cal-OSHA is pretty much the same as the word for the year for employers, and that is stress. You saw those statistics that Andrew pointed out concerning the number of inspections and citations issued had a peak a couple of years ago and then seems to be dropping off. And we can't be sure because the division is not totally open about this, but a couple of years ago, the division was caught feeding promotional questions to applicants before the test. And as a result, hiring was taken over by the Department of Personnel, State Department of Personnel, and there was a hiring freeze at all levels. So the hiring freeze is pretty much over now. Everyone has been retrained on how to properly handle an interviewee, and they're beginning to advertise for new COSHAs. At one point, they had 60 openings statewide, 60 openings statewide for inspectors. My understanding now is that it's somewhere around 40, but that's still a high number. The issue with the new COSHAs they're hiring is that many of them are coming straight out of college and university. They don't understand from small business perspective what it takes to make a profit. They don't understand from a large corporation how things work inside the corporation and what pressures and what factors impact safety and health decisions there. It all goes uphill as well. There are 6 different district offices that do not have managers. Some have not had them for months. One regional manager is, or one region is without a manager. The legal unit in Southern California has 4 openings out of 9 total. And so they are highly overworked and trying to maintain the status quo there. Bureau of Investigations, which has responsibility for criminal investigations following serious incidents, they're all, or were all, deputy sheriffs, retired, and the like. In Northern California, we have 1 who's working half-time, In Southern California, we have 2 out of what used to be 6. And so you would think that things are coming to a standstill. But the upshot is there are still a number of citations being written based upon quick investigations and, frankly, some shoddy investigative techniques. The records for citations that we see are not complete and have large gaping holes in them. Next slide, please. Should mention before we go on that it applies also to clericals. There is a real lack of clerical support, especially in Southern California, that is slowing up works within the division itself, but they still carry on. That's the happenings at OSHA for the moment. I want to talk about a Senate bill that was just recently introduced by Senator Gonzalez from Long Beach. This bill should raise concerns among all employers in California, big and small. She is going after egregious employers, and to the extent that she, if this bill passes, would provide an opportunity for the division to issue a citation per affected employee. Instead of going into the worksite and citing for just the one hazard, they would go into the worksite and cite for the one hazard times how many employees may have been exposed to that hazard. The thing about this bill is that there are no definitions provided. There's no way to tell what an egregious employer is. It's all subjective language. No reasonable effort to eliminate the known violation. Persistently high rates of worker injuries. What does that mean? Extensive history of past violations. Intentional disregard. And then I like this one. Conduct taken as a whole amounts to clear bad faith. There's nothing objective about that standard. Next slide, please. But that's not all this new law would do. It also would give OSHA jurisdiction to enforce the health and safety code in the workplace, not just the labor code. And it creates a rebuttable presumption that if any quote unquote adverse action is taken against an employee within 90 days of certain acts, the employer is on the hook to explain why it was not retaliation. And those events include disclosing positive test results for a communicable disease, asking for testing as a result of exposure, requesting personal protective equipment that is, quote, reasonable under the circumstances. And then this is redundant because it already is the law, reporting a possible violation of the safety regulation. Can't retaliate for that. This is a bill that has drawn opposition from the California Chamber of Commerce. If you're members of the California Chamber, you should get in touch with them and tell them that you're on board with opposing this bill as well. Next slide, please. So let's get into a little rehash of the COVID-19 ETS. Next slide. And this, I want to go over the history of this just for a moment. There's one date on this list that you don't see, and that is the date of, bear with me, May 20th, 2020. On May 20, 2020, WorkSafe petitioned the Standards Board for this emergency rule. And it took them 4 months to decide to grant the petition. And then things accelerated from there. It took 2 months after that to publish the draft. And then in the 7 days following that, that was all the time the public had for comment. And then the Standards Board met and voted on the rule after a marathon, and I mean marathon, Zoom conference throughout the state. ETS was approved by the Office of Administrative Law, and it now is being, there's cleanup legislation, as they say in the legislature now, to try and figure out how they can amend the regulation to be a little more transparent, a little more clarity, give it a little more clarity. And so we'll see what happens with that. They had said that they were not going to do anything to it until this coming October. But the word we get now from the board, from the division, is that they're looking to submit recommended amendments to the Standards Board sometime in the summer. Next slide, please. As you know, it applies to all workplaces, the emergency temporary standard does, unless you're working from home or don't have contact with anyone else. I guess that includes fire spotters in towers. It also does not include employees who are already subject to Section 5199, aerosol transmittable diseases. That's generally workplaces in healthcare and the like. And then there's a note at the end saying nothing in this ETS is intended to limit more protective or stringent state or local health department mandates or guidance. We'll talk about that in a bit. Megan has something to say on that score. And now we're more deeply into it. You know that you need, in addition to the IIPP and the heat illness plan and all the other plans, you need a written COVID prevention program. And it's highly similar to the illness and injury prevention plan. If you have an IIPP, you're well set up to create a COVID-19 prevention plan to cover communication, investigation, inspection, correction, training, all the subsections of 3203A that you're familiar with. Next slide, please. Thing about the ETS is that it really places a burden on the employer to do a lot of things quickly once an exposure is reported. You have a single business day to give notice of exposure blindly without revealing who was actually exposed to all employees who you can identify as having close contact. Just identifying those can take a little while, but you need to do it within a business day, and to their union. And that notice needs to be in writing. You're also responsible to give notice to any independent contractors and other employers, whoever they may be, present during the high-risk exposure period. You have to offer free COVID-19 testing. That has to be given to the employees while they are at work, so they don't lose personal time and they're paid for it. You need to exclude COVID-19 cases and exposed employees from the workplace for a specific period of time. And you're also obligated to immediately investigate and determine possible workplace-related factors that contributed. Next slide, please. So here we have the CDC's distancing and face covering requirements written into our law. Employees are to be separated by at least 6 feet, unless you can demonstrate that 6 feet of separation isn't possible, or where there's simply momentary transitory contact between the employees. If 6 feet is not possible, then you need to make sure that they are as far apart as possible. Employers shall provide face coverings and ensure that they're worn. Next slide, please. By the way, back up one slide. I want to say something about that. The face coverings, this is not as onerous as the requirement for N95 respirators that Andrew will talk about later under the wildfire smoke rule. But these are everything according to the guidance from OSHA. This is everything except gaiters or bandanas that used to be worn by train robbers. Next slide. So now we get into engineering and administrative controls that you have to consider and implement when possible. I want to talk about clean solid partitions here for a minute. There appears to be, and I've just learned this today, but there appears to be interest statewide among OSHA's inspectors in determining whether plexiglass partitions at checkout counters are sufficient in their estimation. We have no guidance from anywhere as to what the dimensions of a partition ought to be, but I know of at least actually three incidents where COSHOs, safety inspectors, have gone into retail stores and took very close look at how extensive the plexiglass partitions are around clerks. More later, I suppose, on that one. Then we have to talk about whether or not you have a adequate ventilation. We're hearing from the CDC and NIOSH that ventilation can be the key to reducing the possibility of contracting COVID in the workplace. So to the extent that you can, you should look to maximizing how much outdoor air is pumped into the workplace, either through an existing mechanical ventilation system or by opening windows, unless you're going to freeze everyone out or create a heat illness problem. You also need to have a very specific plan in place on how you're going to clean and disinfect areas that may be touched by a number of different people, including the public, how you're going to go about cleaning those off, and how you're going to inform your employees and their unions of these procedures. A word on that, we recently had a client come to us and say that they were being, they had a union that was demanding that they provide documentation of their procedures for cleaning and disinfecting the workplace. And if you take a close look at the regulation, you'll see that the employer is responsible for giving notice to employees and their representatives of their program for cleaning and disinfecting, but you don't have to provide them with documentation of all the times and all the efforts you've made to disinfect. Next slide, please. Pay and benefits. This is the infamous subsection C10 of 3205. And it's probably the most poorly written clause in the regulation. It is dense and it's hard to understand, especially even OSHA has difficulty understanding what they've said. COVID-19 cases and exposed employees have to be excluded until they meet a return to work criteria. That the employer during that period has to maintain their earnings, seniority, all other rights. If the employee is excluded but would be able to work except for the exclusion. In other words, if they are well enough and not communicable and could work, the fact that they are excluded because they happen to be exposed shouldn't deprive them of their earnings. So if they're ready and able to work but can't for reasons of COVID exposure, you need to provide pay. You can provide that pay through use of sick leave benefits, but you need the employee's consent in order to do that. And there's one important exception to this rule that you should be aware of. Pay continuation at the bottom of the slide is not required if you can demonstrate that the exposure to COVID-19 was not work-related, that it came from somewhere outside of the workplace. And that can be done partially by making inquiry of the employees themselves, or just doing some contact tracing of your own within the workplace and asking the employee about what's going on outside the workplace. To that end, we also had an inquiry from a client saying that there was a co-show who was demanding that they give them the name and contact information for the person the employee thought gave them COVID-19. And this person is not an employee, is not related at all to the work site. So it would mean that the employer would have to take steps to go beyond the premises to get in touch with this person and provide that information to the division. And we take the position that you do not have to do that. It's so long as you can demonstrate either through the employee's statements or otherwise that the infection was not work-related, that's where the analysis ends. Next slide, please.
Oh, actually, Fred, I did want to address one issue, and this comes up in the context of the COVID-19 supplemental paid sick leave that just passed last Friday, that there was a bit of, Megan, if you could go back one slide. Okay, and I think I was going to chime in anyways at this point, but there's language in the ETS about an employer being able to apply employer provided sick leave to meet the earnings continuation requirement under the ETS. And there's been some guidance from the labor commissioner indicating that that would not be permissible unless you have the consent of the employee based on the right of the employee to indicate whether he or she wishes to use the employer provided paid sick leave for that purpose or any other. But since the COVID-19 supplemental paid sick leave has just passed, that's up to an amount up to 80 hours for a full-time employee. That will be the bucket from which you will want to first apply to the earnings continuation requirement. And then secondarily, you can look at the employer provided sick leave benefits if you have the employee's consent. But I think we can move to the next slide that addresses our coalition that we formed in advocating in the advisory committee process. And so we have formed the California Employers COVID-19 Prevention Coalition. It has had an array of different employers from a variety of industries. And we have presented comments to the Standards Board as part of the rulemaking process over the ETS. And then are also serving on the advisory committee, as Fred mentioned, that's essentially designed to clean up the regulation. And there is a proposed amendment essentially by DOSH on that rule. And there's other changes that have been requested by our coalition, among others. And so, but I just wanted to discuss very broadly some of the issues that we raised with the ETS, and we're hopeful that there will be some much needed clarification and changes. But one issue is relating to the use of partitions for fixed work sites, such as a cashier or other worker that cannot have free movement. And it's crafted in a way that does not provide much flexibility. And there is an evolving science about what the effectiveness is of partitions, given that COVID-19 is airborne. And that's something that we believe needs to be finessed. And that there should be an exception to the physical distancing requirements. They're fairly rigid in the current iteration of the ETS. We've also addressed relaxing the quarantine and testing requirements for vaccinated employees. At the advisory committee, we had a lively discussion about vaccinations, and there seems to be consensus over the need to recognize, at least for quarantine, some sort of exemption if the employee has been vaccinated and is a close contact to a positive case. And that's something that we're hoping will be incorporated in some form in the amended ETS, and we have proposed language for the agency on that. then we believe that that exemption should apply as well to testing requirements for someone that's been vaccinated. And then also various different recommendations that we've had around the outbreak definition. You know, as many of you know, the definition of an outbreak that triggers all of these onerous additional requirements, particularly around testing and, well, in quarantine as well, but that's based on a number of cases that you identify in the workplace during a certain time frame, whether it be a regular outbreak or a major outbreak. And the issue that we're encountering is that is not based on epidemiologically linked cases to the workplace. You could have, and many of you may have encountered this, employees returning from Thanksgiving or Christmas time, and you have a number of positive cases. That does not mean that there's been a spread of COVID cases in the workplace. And so that's something we've sought to have addressed in the rule itself. Let's turn to the next slide. And I'm going to turn it over to my colleague, Megan Shickhead, to discuss return to work criteria.
Thanks, Andrew. So while the advisory committee and the division do their hard work of considering whether to amend the ETS, we are still left with the current version of the ETS for now. And I'm just going to go over a couple more kind of key points of the emergency temporary standard before moving on to some related legislation that came out in 2020 and became effective in the beginning of the year. So the ETS, just continuing for a few moments, the return to work criteria that's laid out in the emergency temporary standard and altered slightly by an executive order by Governor Newsom, dictates that that the return to work criteria for a COVID-19 case with symptoms is the passage of at least 24 hours since a fever, since resolution of the fever without use of fever reducing medication, an improvement of the COVID-19 symptoms, and at least 10 days since the COVID-19 symptoms began. So that's for COVID-19 cases with symptoms. If you have a COVID-19 case that's asymptomatic, those folks may not return to work until a minimum of 10 days have passed since the date of the positive specimen collection. And then if you have individuals who were exposed to COVID-19, but who never tested positive and did not develop symptoms, then those individuals may return in 10 days following the exposure. And that's the part that if you read just the straight emergency temporary standard language, you might see a 14-day period, but the governor came out with an executive order that the division has adopted in their frequently asked questions and recognized that, yes, that executive order acknowledging that a 10-day period for exposed individuals without symptoms and who do not test positive, that 10-day period is appropriate. And then an important part about return to work criteria is that a negative COVID-19 is not required. It also is not grounds for returning somebody to work earlier than the return to work criteria otherwise provide. So Andrew mentioned as one of the topics for the advisory committee is the outbreaks. And so I just want to mention very briefly how outbreaks play into the emergency temporary standard. So there are two sections of the emergency temporary standard that have to do with outbreaks and major outbreaks. And it provides that certain requirements have to be complied with if a workplace is experiencing an outbreak or a major outbreak. So a workplace is kind of in this outbreak bucket if either it's identified by the local health department as experiencing a COVID-19 outbreak, or it meets one of the criteria for outbreak under the ETS. An outbreak, just a straight outbreak, is 3 or more COVID-19 cases in an exposed workplace within a 14-day period. And a major outbreak would be 20 or more cases in a 30-day period. And if a workplace is experiencing an outbreak, then a number of requirements are triggered and they have to be complied with until there are no new COVID-19 cases in the exposed workplace for a 14-day period. So the major kind of topics to think about when talking about outbreak requirements, number one is testing. And testing is going to have to be provided to all employees at the exposed workplace. The testing has to be free. It has to take place on a certain cycle. So if you're in the regular outbreak criteria, it has to happen weekly. In major outbreaks, it has to happen twice a week. And the testing has to continue until, again, there's no new COVID-19 cases within a 14-day period. The requirements also include excluding those COVID-19 cases and employees with exposure from the workplace until the return to work criteria has been met. There's also a requirement, and it varies slightly for major outbreaks, but it's essentially that the workplace investigate the cause of the illness or the exposure, and then review your plan and consider whether any changes need to be made to, beef up the procedures for preventing spread within the workplace. And then there's also notification requirements to the local health department, which I'll also discuss in a larger context in a moment. And again, major outbreaks have slightly some additional requirements around ventilation and other such things. And then I'll mention just briefly for those who may have employer-provided housing or employer-provided transportation, that there are two subsections, section 32053.3 and 0.4, that lay out specific requirements for those employer-provided housing and transportation. And they cover things like prioritizing the assignment of the housing or transportation, and cover details like physical distancing, disinfection for transportation, ventilation, and other such requirements. So if that's something that applies for you, you'll want to take a closer look at those subsections and make sure you're complying with those as well. So we've mentioned that a couple of times that there's notification requirements or reporting requirements, and a couple of bills I want to mention because they kind of intertwine with the emergency temporary standard are Assembly Bill 685 and Senate Bill 1159. So at the end of 2020, we had these two bills. And they were passed. And the first Assembly Bill 685 went into effect January 1, and it essentially has two parts. The first is a written notice requirement. So unlike the ETS, which has a notice of potential exposure requirement, the Assembly Bill 685 has a much more onerous requirement for that notice. The notice must be in writing, and there may be some changes to the emergency temporary standard to better align the ETS requirements and the Assembly Bill 685 requirements. But for now, 685 is where the requirement for written notice comes from. And it does need to be provided within 1 business day, which is similar. If you have a unionized workforce, the union also needs to be provided notice, and any employers for subcontractors on the work site need to be provided notice as well. 685 is not the clearest bill that's ever been written, so there's definitely some ambiguity and some confusion, but it raises, but it does provide some very specific detail on what needs to be provided in the notice. So notice to employees, notice to employers of subcontractors, and notice to the union all have very specific requirements of what needs to be provided in that notice. For example, employees and their union need to be provided information about COVID-19 benefits and, the safety and kind of disinfection plan for the work site. So it's definitely something to look at in more detail. 685 also has a second component to it, which is reporting requirements to the Department of Public Health. And their COVID-19 outbreaks need to be provided. Notice of COVID-19 outbreaks needs to be provided to the local health department. It needs to be provided within 48 hours. And then in turn, the State Department of Public Health is supposed to make this information available. So, there's a little bit of transparency to the public about the frequency of COVID-19 outbreaks and how that's playing out in industry. So a pretty onerous requirement and a bit broader than what's strictly required in the emergency temporary standard. Since AB 685 requires a written notice and requires that specific things be provided in the notice, and then since the emergency temporary standard also provides that certain things be provided, it's good to kind of read those in tandem to make sure that you're providing all of the information that you're required to, but that also you're, to the extent possible that you're being as efficient as possible in your notices, in your required notices to employees and related parties. Senate Bill 1159 is the second piece of legislation that we wanted to highlight. And this also, you can think of it as having two parts. The first is a disputable presumption that a COVID-19 illness is compensable for workers' compensation purposes. And this presumption exists where an employee tests positive during an outbreak at the workplace, and that they were at the workplace within 14 days, and that the employee's last day in the workplace was on or after July 6, 2020. So the history here is that at the beginning of the pandemic, there was kind of a patchwork of rules that came out, executive orders, SB 1159, that allowed workers' compensation coverage where it might otherwise be more difficult to get coverage, given that COVID-19 was spread so prevalently in the community. So the presumption is the first part, and then within that presumption, the definition of outbreak is different than the definition of outbreak than what we consider an outbreak to be under the emergency temporary standard or AB 685. So for these purposes, for SB 1159 purposes, an outbreak is looking within a 14-day calendar period. If you have between 1 and 100 employees, you have to have 4 employees test positive for COVID-19. Or if you have more than 100 employees, then it's 4% of the employees at a workplace. Or if the workplace is ordered closed by the Department of Public Health or Cal OSHA. So important to just remember that the outbreak definition is a little bit different in that context. And then the second part of Senate Bill 1159 is a notice requirement or reporting requirement to your workers' compensation claims administrator. And within 3 business days of an employer knowing or reasonably should have known of an employee testing positive, you have to provide very, very specific information to your claims administrator. And so that's something to track as well, as if the emergency temporary standard is not confusing enough. And that's not all, there's more. So the other things that we, and this is what Fred was alluding to earlier when he said that the ETS notes that nothing in this ETS is intended to limit more protective or stringent state or local department mandates or guidance. It's really important that employers are also looking at a number of other resources that kind of have to lay on top of the state requirements. So you have the emergency temporary standard out from Cal OSHA, And that needs to be reviewed in detail. And there's also guidance from Cal OSHA in the form of frequently asked questions that they're updating periodically on their website that helps the general public and understand, and us even understand, what the ETS means. But then there's also guidance from the California Department of Public Health, the CDC, NIOSH, that are sometimes you'll have the ETS or AB 685 reference something from the California Department of Public Health. So then you might have to turn around and check for the most recent guidance that the CDPH has put out on a topic. For example, the current definition of an outbreak. And then you also have to look at your local health departments, your local county or city, to see if there's any guidance or ordinances or other rules that might be more strict than what's required at a statewide level. Make sure you're complying with those depending on where you have operations and where you have employees working. And then, as we saw with the slight change to the return to work criteria, the governor's executive orders can also play an important part in figuring out what the rules are when it comes to COVID-19. And with that, I think we'll pass back to Andrew to talk about wildfire smoke.
All right, thank you, Megan. We have a number of questions about the ETS, and we'll cover them at the end, as many as we can. But the last subject is the wildfire smoke standard, and that standard was it's an emergency temporary standard. It has been recently amended in the last year, and this is a standard that, nowadays is impacting so many more employers, and the greatest consternation here is really over the shortage of N95 respirators and how that impacts businesses, particularly during the pandemic. But in a nutshell, this standard applies to where the air quality index for PM 2.5 is 151 or greater, considered unhealthy air. And another prong to the scope or the coverage here is that the employer should reasonably anticipate that employees may be exposed to wildfire smoke. Ask me what that means. I can't tell you. It's very ambiguous, and so we're not quite clear on how DOSH will interpret that. I don't believe there's been any guidance on that. And there are some significant exemptions here. We have, and there's been some clarity around this in the latest amendment, but if you have an enclosed building with air filtered mechanical ventilation system, and the openings are kept closed except for entry and exit from that building, then that building would be considered exempt from this the scope of this rule. The same goes for vehicles, where you keep the vehicle doors closed except when you need to get in and out of the vehicle, then that wouldn't be covered by the rule either. Another exemption, which is sort of inconsistent here with the application, the scope here, is that if the employer demonstrates concentration of PM 2.5 in the air does not exceed thresholds by measuring the levels in the worksite, then it's not covered. And then if the employer can show that the current air quality index doesn't reach 151 or greater for more than, or let me state this correctly, if the employer is exposed to, sorry, here my slide just got obscured, but it's the threshold is essentially an hour or less of exposure at 151 or greater. If that's the case, then you're for an employee, then that employee would not be subject to the rule. And so that presents an interesting question where you have workers that just have incidental exposure outside, then perhaps structure your operations in a way where you don't have employees going out all the time, that they might just go out for a brief duration, depending on the nature of your business. Let's move to the next slide. So regarding, oh, next slide. There's several different requirements under the standard, and the most significant relate to identification of harmful exposures, and that requires that you either check the website of a approved entity like EPA on the air quality index in your region. The rule is not clear exactly what area you should be checking, and that's another ambiguity we sought to address in rulemaking. But you essentially can check the air quality index through the governmental website, or you can conduct air monitoring of your work site, and that might be a benefit if your work site is in an area where there's not a wildfire smoke hazard and there might be in an adjacent area. And then you have a requirement to communicate with your employees about the hazards, what the air quality index is, if it is going to exceed the limits, what the measures that will be in place to address that. And it's important also to mention regarding identification of harmful exposures that there's an obligation to monitor at the start of the shift and periodically thereafter as needed. And then there's some detailed training and instruction requirements. There is an Appendix B to the standard that does identify content for that training. And then really lastly on the next slide, this addresses the concern that we expressed through our coalition during the rulemaking process about the shortage of N95 respirators and seeking some sort of reasonable alternative. There has been none recognized by OSHA and general industry, but we did want to provide you a resource here that the division has identified a list of vendors who report available supplies of N95s and are approved by the agency, and that's on the agency's website. And the N95 respirators must have the head straps, and we provide an example here of one. OSHA only lists vendors who state that they have 100,000 or more masks in stock. There may be others that you are able to access. The bulk pricing for masks ranges from $1.75 to over $8 each, so it's very expensive. We have encountered clients where they have someone on staff who's just tasked with ordering N95 respirators, searching for them and ordering them. That's obviously not something that's feasible for most employers. And so it's been a really source of frustration for businesses, and many have stocked up on N95s before the fire season and have been able to obtain a greater stockpile at a kind of reduced cost, but I'm sure that's something you're all encountering. And so that's the end of the content for the webinar. There were some questions we wanted to answer, and this is some information about our task force specifically. And then on the next slide, just so you have it, we do have blogs on OSHA Defense, as well as our OSHA blog and Employer Defense Report. And we have a webinar series. And so for more information on these subjects, you can go to our website. But there were a couple questions here that, first off, there was a question about the COVID-19 supplemental paid sick leave. And one participant had asked when that takes effect. And that is March 29th. So it's coming up, I believe that's Monday. And so you'll want to be aware of that. There are some frequently asked questions, FAQs, on the Division of Industrial Relations website that you can access for more information. And we're still digesting that. We expect to have a blog article posted soon on that. There was a question about, and Megan or Fred, if you want to address this, there was a question about for persons with a COVID-19 exposure without positive test or ever confirming symptoms, is it 10 days from first exposure or the last exposure? For example, roommate tests positive on COVID on 14-day quarantine. Is it from the first day of quarantine of roommate or last day of quarantine. And I think that's...
I think it's the first day. I think you go back to the first day of exposure. You know, I've been doing this stuff for over 30 years. I hate to say it, but I have never seen a more convoluted and dense and opaque regulation than this one. It just, as a friend of mine said, he used to dread every day. No, he used to dread the, forget it. This stuff is amazing. He said, I used to be overwhelmed by it all, and now I simply dread one day at a time. We're always coming up with questions, and we're always coming up with new explanations. And one thing that wasn't mentioned was that we now have an interpretation letter from Fed OSHA, which says, in rather guarded language, that nothing but the regulation is sufficient, that the guidance documents, the FAQs, those are not regulations, and they don't necessarily, shouldn't necessarily be followed. I may be misphrasing that. Andrew, you can fill in the blank on that one.
And I want to add to that, you know, we've had much debate internally with our OSHA team, and we have lots of experts in this field, and we've had many different interpretations in the life of the standard, and they've evolved with the guidance that's issued by DOSH. As Fred mentioned, the DOSH guidance has no binding effect, and so it's not something we can cite on appeal to the appeals board with OSHA and, you know, indicate that this is what the position DOSH is taking, therefore the board should do the same. So that's a source of frustration for us, and that's why we firmly believe that the rule needs to be appropriately amended. But under the guidance, okay, so this is the problem I'm seeing, is the current iteration of the rule does suggest that you quarantine for an exposed individual from the last exposure. That would be the benchmark. Though the DOSH is amending the rule and the proposed language suggests otherwise. It's not so certain in that way. And then their FAQ states that based on CDPH guidance that, based on the executive order that issued, narrowing the quarantine period from 14 to 10 days, that the quarantine would be from the date of the last known exposure. So I suspect you could get different answers here from the agency. And so I think a cautious approach might be to quarantine based on the last known exposure.
John Canepa asked a question that I thought was interesting. He said, when asking for, quote, testing results, close quote, does that concern drug and alcohol testing post, and I don't know what else was there. Yeah, I think he's talking about the new SB 606, talking about the retaliation provision there, 90 days after you have requested testing results. I think that's what he's talking about. And if that's the case, John, there is nothing specific in this new piece of legislation. I don't know what testing results implies or means. It could be interpreted to mean any kind of test, not just COVID-19.
You know, there was a really interesting question. Can you please clarify who has the burden of proof regarding work-related versus non-work related? And that's the million-dollar question. And,
it is.
And if you're looking at it from the vantage point of earnings continuation, where there's an obligation to continue earnings while an employee is excluded from the workplace, then I'm reading that language to place the burden on the employer to demonstrate that the exposure is non-work related.
I would agree. And in practical effect, when an inspector comes in, looks around, and is his fingers are itching to write a citation, it's going to be to the benefit of the employer to take the burden on to show him or her that no, this is not worth writing a citation for. So in that sense, yes, the burden falls on the employer as a practical matter.
And we've advised fairly consistently that where work relatedness is relevant, to make sure that you've properly analyzed, assessed, and documented that. And so if you're considering whether to continue earnings for an excluded worker, whether you're considering logging the illness on your OSHA log, or reporting the illness to OSHA where it results in inpatient hospitalization, then you really need to have documentation supporting your determination. And we encounter quite often, and that leads to a really good question by one of the participants about where have you seen employers making the most mistakes when it comes to these different regulations? So we're not going to disclose all of this right now, but in detail. But it's really that's an issue that I've encountered, though, just generally, is that we have a business that concludes that a COVID case is not work related, but then you start looking at the documentation that shows that there's no support for that. And given that we're dealing with this regulatory agency that can be aggressive, we feel that you should have a fairly strong case that the illness is not work related if you're going to make a key decision based on that.
Right.
Anything else that you can think of, Fred, about a key mistake or pitfall?
No, it's so new. It hasn't been subject of enforcement for very long. We don't know what the division is finding in their inspections just yet. In my experience, it's all pretty much revolved around, well, it varies. If you have people who are doing retail work, there's a big issue now as to whether all the plexiglass that they've bought and put up is going to be considered adequate. There are questions about, it kind of rolls over into high hazard and smoke. Are you going to allow workers to carry groceries out to somebody's car and come back? But no, I haven't come across any one or two things that are pitfalls for the employer. I think there are pitfalls all the way through this regulation.
And a word of advice that I have for many is that if you are going to classify the workplace as an outbreak, make sure that you've consulted with counsel or other expert, because once you've classified the workplace as an outbreak, you have an obligation to conduct what could be an almost never-ending cycle of testing, really dependent on how far we get with the pandemic here. So there's a bunch of really significant legal considerations there. I did want to just respond to a more straightforward question about KN95s and whether they're approved for wildfire smoke. They are not. And from what I understand from the division directly is that they have tested the N95 respirators and they've concluded that they're not sufficiently effective to be a substitute to N95. And we don't have access to the data and details to support that conclusion. But that's something that we've been striving for, because clearly N95 respirators are not available in sufficient quantity.
Right. And the issue with the KN95 is if you can find one that is authentic, it might be approved by NIOSH, but there are so many counterfeits on the market that you can't trust it. You should only go for the N95. And while we're talking about wildfire smoke, I wanted to mention something else about how do you determine what the air quality is. There is a handy dandy app for your phone from the EPA called Air Now. And if you download that app, it's AIRNOW, one word with a capital A, capital N. If you download that to your phone and put in your your postal code, up comes your air quality in vivid color. So I recommend you take a look at that.
All right, I think we've gone quite a bit over the time. We thank you all for hanging in there with us. And if you have further questions, you can reach out to any of us directly. And there is more. I don't know if you can go back to the preceding slide. That's a list of all of the webinars that we have for this remaining year. If you'd like to find a topic there that interests you and you'd like to join. Thanks again for participating.